Good morning and welcome to today's webinar presentation, Estate Planning and Elder Law Essentials, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be your moderator for today's presentation. We appreciate those that are here today for the first time. We have several new attendees as part of our educational Elville webinar series, and also to those that are frequent attendees as well. You've come to the right place for high-level legal education. We encourage your general questions today, so please note them in the questions panel on your screen, and we will pause periodically throughout to address them. Your questions, as always, help the presentation, they add value and help others learn, so don't be shy in posing your questions at any time. You also received the presentation slides by email from me yesterday to take notes on them if you wish. The materials are also available in the section marked handouts in the panel on your screen to download at this time. For our professionals on today's webinar, a warm welcome as well. 1.5 continuing education hours are available for most everyone in attendance. So if you'd like to submit an ID number and your accreditation for me to provide a certificate of attendance, or submit your information to the CFP Board of Standards, please send that information to me today if I don't have it already. Everyone will also receive a post-webinar feedback email right after the presentation, so please take a minute to fill out this brief survey to offer us your feedback about the presentation. And as always, we read and value every comment that you have to offer and share with us. Here at Elville & Associates, we always want to be a resource to you for your families and your planning needs. So if you do have planning needs that you have to address, old documents that need to be reviewed, or perhaps another matter, consider a consultation with Steve after today's presentation. Use today's education as a jumping off point to get your planning started. Consultations are a great way, an ideal way to get your specific questions answered, have Steve understand your situation, and help create solutions and a path forward for you. So we're going to get started here. I'd like to give the firm and Steve a proper introduction briefly, as I always like to do. So you should be able to see my screen here. Elville & Associates, we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We have several different practice areas that we offer here and focus on at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 9 attorneys, 12 staff members in 5 locations. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do focus on education a lot here at Elville & Associates in several ways. Through our planning processes with our clients, we offer many educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program. We're one of only 2 firms in Maryland to have an accredited client care program through the Client Care Academy in Boston. We also focus on the ideals of client education, collaboration, and compassion with every client every day here at Elville & Associates. Just a bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection, among many other areas. A member of many different national membership organizations, he works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, offering many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year, so congratulations there, Steve. Steve also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I'm very fortunate and privileged to be the executive director of. If you'd like to learn more about the Elville Center and how we are working to make a musical difference in the lives of children each day, I would love to share our story with you, so please feel free to reach out to me when we have just a bit more time. But today we're going to talk about estate planning and elder law essentials, a very important topic in and of itself. Before we do that, I've got a poll I want to share with you. We'd love to get to know our audience just a bit and ask you what brings you to today's webinar. So a pretty simple poll, but we'd love to get to know who you are and what's brought you here today. And the choices are: 1, I am new to estate planning and need to get started. 2, I have a plan in place, but it is outdated and needs updating. That is not unusual, so it's okay if that's the case. 3rd, I feel my plan is on solid ground, but education is always great. And lastly, I'm an advisor here to learn to better serve my clients. So make the choice that suits your situation. Appreciate you being here today on your Friday before Labor Day weekend. Hope you have some great plans. What better way to kick off a Labor Day weekend than doing a webinar about estate planning and elder law, right? I can't think of one. All right, give another few seconds here. All right, we've got about 3/4 of the people having cast their choices. 33% say I am new to estate planning and need to get started. 19% say I have a plan in place, but it is outdated and needs updating. 28% say I feel my plan is on solid ground, but education is always great. And fourth, 21% say I'm an advisor here to learn to better serve my clients. So whatever brings you here, welcome again. Steve, I'm gonna close the poll out and make you the presenter.
Thank you so much, Jeff. Really appreciate it
Right.
and your introduction. And I'm just going to jump in where you've left off and get my screen up. And we're going to start our slideshow. And I welcome everyone on this beautiful Friday morning here in Maryland, where I am, in Columbia, Maryland. And we really appreciate you being here. It's my great privilege, as I continue to adjust my screen here just a second. It's my great privilege to be with you this morning, and without you, we could not do these webinar series that we do at Elville & Associates, so thank you. We know you have many choices today about where you would be here at 10 o'clock on a Friday morning before a holiday weekend, and I hope you have a safe and wonderful time over this long weekend. And wherever you are this morning, I know you come here with certain questions and certain interests in estate planning, and we thank you for participating in the poll. So we want you to know that we are thinking about who you are and what you might be thinking about this morning in being here. So I want to give you, I want to fulfill, I guess, the purpose of the webinar, which is to give you something substantive to walk away from, something that you can actually use. And I think if you look at this webinar as a mini masterclass on the basics or fundamentals of estate planning and elder law at a very surface level, but still very substantive because it's a very broad area, I think you'll know and the assurance, or have the assurance, that you know more than about 90% or 95% of people know about estate planning. So thank you for being here, Jeff. I thank you for everything you do and for our long collaboration on these webinar series. And I thank all the associates and staff here at Elville & Associates, without whom I could not do what I do. So as we start the webinar, I want you to know this is going to be not only interactive like it normally is, but I'm going to make this webinar a bit more interactive than normal. So I'm going to ask you to participate, and many of you will have questions and concerns as we go along. Jeff will field those questions, as he always does. I will do my best to answer those questions at a high level, even though, as I'm going to tell you here in just a second, we can't provide legal advice over this webinar. But beyond that, beyond your normal questions, we're going to ask you to participate a little bit in an interactive way to make this the most high impact webinar that it can be for you. So here we go, and I thank you again for being here, and happy holiday weekend to everyone in advance. As I just mentioned, we're going to be talking about a lot of concepts. We're doing this virtually. We don't have an attorney-client relationship, either virtually or otherwise, because we haven't been engaged. We haven't actually talked about certain issues that you may be concerned about. So just know this cannot be construed as legal advice. It is high-level estate planning education. And just before I leave that topic that Jeff mentioned earlier, this education is not only as far as you are concerned, but we want you to look at it as one step beyond that. We want you to look at this as education for your potential fiduciaries, the people who will be making your decisions for you in the future, or if you can't do it yourself. We also want to extend this education to your children who may be those fiduciaries, but they may play other roles, such as they may be administering your estate. They may be the trustee of their own trust someday. So we want to educate you, we want to educate your family members, and we want to educate your collaborative team, which we're going to talk about. So let's talk about what we're actually going to cover in this presentation. Well, we're going to talk about estate planning, what it actually is, and what is a process of estate planning. So it's one thing to have a plan, it's one thing to have a plan that works. It's a different thing. So we want to make sure that. And that's really what this second bullet point is all about. We want your plan not to fail. We want you to put something in place that will actually work. We want you to know that it will work, and we want your team to know that it will work. We're going to talk about wills versus trusts. This is the conversation, I should say, about probate versus non-probate. Many people in this country have this question, you know, should I have a will? Should I have a trust? What do I do with my existing documents? We're going to cover those concepts. And then we're going to get into the kind of ancillary concepts of elder law, taxation, asset protection on a very high level, giving you the feeling that you need to have, or the sense of those topics, so that you can be able to think through those issues as it relates to your planning, your central estate planning. And then we'll talk about getting started, because as someone once told me, education is great. It's really an essential thing for any calling or any project, but also how do we move forward? What are the mechanics of getting from point A to point B? So we're going to talk about those things. So let's talk about the estate planning process, and we're going to talk about why we want to plan. Why do we want to plan? We're also going to get into this concept just very slightly about why certain estate plans don't really work. And this could be for various reasons. So we're going to talk about why, and you're going to have your own reasons. You're going to have your own reasons why. And the other thing we're going to set right from the get-go here is that every estate plan should be goal driven. Just like what you're going to do this weekend. You're probably, hopefully, going to have some activities planned. You're going to have goals in mind, whether it's getting to a certain place on time, having a family event, whatever it may be, getting to the airport. The idea here with estate planning is that we are getting ready to take a trip. And that trip, we're lifting off. And what is the purpose? What is the goal? And we want you to have a goal. And for some people, this is going to be straightforward. We're talking about certainty. Well, we want to articulate and structure a certainty for our loved ones, for ourselves. Smooth administration. Some people are very, very concerned about this. We want to plan, but we also want to have this smooth administration at the end. And that's very important. That's part of planning. The cost of planning, we want to address that. You know, this is a big issue, and we want to talk about a transactional kind of cost versus an overall cost. Asset protection for loved ones, taxes, minimizing and eliminating taxes, or maybe that's not a goal, although it is for many people. Special purposes, charitable purposes, particular loved ones that have special needs or particular concerns, or your own definition of estate planning. So Jeff and the audience here, I would like to take in our first interactive foray, I would like to set aside maybe the next 60 seconds, and I would like you to just take a deep breath for a second and say, okay, I'm listening to all this information, but what is my goal in estate planning? What is it? And I'm going to give you 60 seconds to really think about that, and I'm going to start the timer now. So we're going to talk about this or think about this for 60 seconds. What is my goal? Why am I interested in estate planning or in updating my plan or just learning? What is my goal? And if you don't know your goal, that's fine, because we're going to continue to think about that. And for those of you who are participating and you're writing down some of this, or you're articulating your thoughts about goals and the whys for your planning, if you're willing to share that with Jeff, if one or more of you would like to share anonymously, we would like to know that. And my timer now has gone off. We've ended our 60-second session, and I would just invite you to share with Jeff, if you have the inclination to share, what might be your particular goal. It could be one of these things I've shown here on the slide, or it could be something different. So Jeff, you'll let me know if anybody shares. Now, as we wait for you to perhaps give Jeff some of your information that you may want to share anonymously, let's talk about why are we concerned about planning failure. Well, some plans will fail, and it's usually because of atrophy. It's usually because these plans were not maintained or updated. And for those of you who don't know this, look at the bottom bullet point here. The average estate plan doesn't get updated for a long, long time. And that's for the person who actually does planning. So the average plan does not get updated for about 20 years at a time. And that's basically a 19-year gap is what we know. So plans fail mainly because they're not maintained. And why they're not maintained is usually because the client and the attorney treat the planning as a transaction, which is very common. It's very human, and it's very natural to say, you know, I need some planning, let's get the planning in place, boom, there it is. But that's the beginning of plan failure, because we don't want that. We don't want that single process. We want to have a multi-step process that over lifetime you have the opportunity to update your planning. And there are two types of planning in my view. One of them is what we just described, which is that transactional type of planning. There's no education. Many of you have experienced this. You may have developed a will or a trust in the past, but that trust wasn't maintained. Maybe it wasn't updated, and maybe that's why you're on the webinar this morning. The other one is what I would just call a process-driven plan, and this is the one we want. And we have an entire webinar on this about how to achieve perfection in planning, how to have a process-driven, purpose-driven plan. But we don't want to make the concept of planning so complicated. All we're trying to point out is that there are various ways of approach, and as depending on how you approach your planning, you're going to be in control of whether that planning ultimately works the way you want. So for your information only, this limited approach, this single one-stage approach, is limited for various reasons. There's no updating. The documents are the emphasis of the plan rather than the whole process. There is not an emphasis on the collaborative team and all of the things that I'm going to talk to you about today. So to avoid that, we want to have a lifetime of learning, a lifetime of implementation, a lifetime of maintenance and updating. If you had a classic car, and I know many of you do have these kinds of hobbies or these kinds of investments. If you had a classic automobile, would you let that automobile fade into oblivion? Would you let it deteriorate? No, you wouldn't do that. If you really loved it and it was important to you, you wouldn't. I want you to look at your estate plan in the same way. You're going to maintain this because you love your family members, you are driven by a purpose, and you're going to maintain that plan throughout your life so that it will actually work the way you want. So we want a process-driven plan, and it doesn't matter what this process really is, as long as it's a sensible process, and as long as it's a process that is beyond this one phase, one stage process. So we want your life to be the process, the changes that occur in your life, the unfortunate tragedies that occur in your life, the health changes, the job changes, the financial growth of your life. We want all this to be incorporated in a continuing estate plan. Jeff, did anybody share yet any of their goals or passions or what their thoughts are about estate planning? Because I'm about ready to do another 60-second test.
Thanks, Steve. Yeah, I wanted to find the right time to jump in here. So we did have some people share, and they were somewhat varied, which I think you would not be surprised at. So we had, first of all, minimizing chaos that exists on my or my wife's death.
Love it.
Secondly, I want to help clients protect assets if they have a dementia or other chronic condition diagnosis to prepare for the 5-year look-back period. And then next, my goals are minimizing taxes and leaving the bulk of my estate to my special needs niece.
All right. Boy, I love that. Thank you so much for sharing. And it not only helps us, but it's really interesting. The way those were couched, I could tell they were heartfelt. These were heartfelt goals. So I congratulate you for sharing. And those of you who didn't share but still did this exercise, congratulations, because that's the first step in good estate planning. So congratulations. Thank you for that. Now, I'm going to give you another 60 seconds to think about your own definition of estate plan. We talked about goals. Now I want you to think about what estate planning is to you. Now, this is similar to what we just talked about, but it's a little bit different. A goal is the driving force behind something, but this is what does planning mean to you. So I'm going to give you a very basic definition, and this is just one of 100 different definitions. So this definition is estate planning is about disposing of or leaving your property the way you want to the persons or organizations of your choice at the lowest possible cost. So estate planning in this particular simple definition is about disposing or giving away your property to the persons you want, okay, to the persons or organizations you want, I should say, at the lowest possible cost. And remember, you can give estate planning or give assets away during life, I should say, not just at death. So estate planning could be, you have charitable intentions during life, you have these other intentions at death. Let's take 60 seconds just to think about this, and I'm going to start the 60 seconds now. Your definition of estate planning could include your intentions. What are my goals, values, dreams, visions for the future for my loved ones? How do I articulate this asset protection that I want? Minimizing chaos. That's a wonderful way of describing it. So we have 5 more seconds on this. We'll move on. Okay, I congratulate those of you who participated in this exercise. And remember that as you think about some of the comments I was making while you were hopefully thinking through this, and I apologize for interrupting, you want to remember that you can always use a letter of intent. If you say, yes, Steve, I really like that idea of my intentions being articulated, you can add a letter of intent to the back of a will or trust, and this will describe further your goals and desires in a more informal way, okay? And there's various ways you can memorialize this. And in special needs planning, those of you who are familiar with this know that we can use a special needs memorandum. All right, thank you very much for that participation. Okay, now we're going to talk about one of the greatest questions in estate planning in America, which is, should I have a will or a revocable living trust? So let's talk about a will. And wills by their very nature have to be probated. And probate is the process. It's the process of what? Proving a will to be valid. Proving a will to be valid, and then the process of notification and the process of information and transparency. So that's the process. And some states have more robust or difficult probate than others. Maryland has one of those more robust processes, whereas I understand from our colleagues in Virginia, that their processes are slightly or more easy than Maryland. So probate, in a nutshell, is this process. And I've given you some bullet points here. Although we can provide checklists for administration during probate, we can provide recommended checklists for administration during trust administration as well. So this is by no means a broad overview of probate, but it's some bullet points to give you an idea of what a regular probate estate is like. And you'll notice here that there's a process. The Register of Wills says that the personal representative has to jump through hoops. There has to be transparency. There has to be appraisals and determining how much the date of death values are, notice to creditors. There has to be an accounting. And the cost of probate is somewhere between 4 and 7% on average. So I want to be very clear about this. Probate does not have to cost 4% in Maryland, but it can due to the statutory fees that are allowed. So we want to look at probate as a process. In some places, it's more expensive than others. In some circumstances, it's going to be less expensive than others because perhaps your loved one is going to be your personal representative and not charge a commission, even though it's a lot of work. So probate does not necessarily have to cost this much. In North Carolina, for example, I had an attorney tell me recently that the cost of probate there was somewhere around 5%. So this varies from state to state. And let's take a look now at a will structure. So when you have, or your loved one that passed away, God forbid, has this structure, they have a will. The will is the driving force of the planning. And they have these ancillary documents, and we're going to talk about this later. Powers of attorney, advanced medical directives. What are we really getting at there? Well, we're talking about planning for life, planning for incapacity versus planning at death. So the will-based structure is usually a three-legged stool, but if we're just strictly looking at the will by its very nature is subject to probate. Now, what about if someone has no will? Well, there still is probate if there are probate assets. So let's talk about what probate assets are. And I realize that many of you on this webinar have administered estates or maybe are administering an estate right now for a loved one who has passed away. And so you know what a probate asset is, but for those of you who do not know, a probate asset is really this: an asset that is in the person's sole name, and it has no beneficiary, has no payable on death, no transferable on death beneficiary, or it has no beneficiary like an IRA that has no beneficiary. That IRA is going to go through probate. So it's owned by the individual in their sole name with no beneficiary and no joint owner. It could be a piece of real estate that's in the person's sole name, no joint owner. It can be a bank account, sole name, no joint owner. It could be a life insurance policy, unfortunately, that has no beneficiary. It has no joint owner, obviously, and that's going to be part of probate. So that person is going to have probate even if there is no will. And how is the property distributed in that circumstance? The property is distributed according to the laws of intestacy, the laws of the state. So ideally, everyone would have a will, although arguably there are a select few people, out of 100 people, there will be a select few who, if they had no will, the assets will pass the same way. There are situations like that. But generally speaking, we're going to use a will to drive the assets where we want to go that are part of our estate. And the non-probate assets, meaning IRAs and other assets, we're going to talk about that in just a few minutes. Some people say, you know, I don't want a will. I don't want probate. So this is one of the greatest topics in estate planning in America, is the revocable living trust. So some of you on this webinar have a revocable living trust. And if you do, congratulations, you have a very nice planning tool. But my second question to you is really going to be, is your revocable living trust funded with your assets? Are the assets properly aligned in this trust? Are your real estate assets properly situated? Are your beneficiary-driven assets properly designated to go in coordination with this trust? So having a revocable trust is an alternative to a will. Those of you who do not have a revocable trust and you say, well, what is this? It sounds complex, but it is really just a substitute for a will. So a revocable trust is a substitute, and the revocable trust is only going to do you some good if that trust is funded. So we have two steps with a revocable trust. First of all, that revocable trust replaces the will. So I'm going to show you this graphic. Here you see, the revocable trust has become the centerpiece. The revocable trust drives the plan. And you see that the will, in my example, has receded into the background. So with a revocable trust plan, it takes over center stage. It is the driving force, and it has two steps. It has to be designed, and we strongly recommend the educational approach in the design and the leading edge approach in the design, but it also has to be funded. So here at Elville and Associates, and maybe in your own life, you meet people who have trusts that have never been funded, or you meet people with trusts that have only been partially funded. So we don't want that, because the whole purpose of the trust, even though it has other possibilities, the main purpose is to avoid probate. So as we go back, we see that the revocable trust is really just a substitute for a will. It has to be funded. Does it provide asset protection? No, it doesn't. Does it provide asset protection if we plan for asset protection for someone else other than you? Yes, it can provide for that kind of asset protection, but not for you. Remember, it is a glorified will that avoids probate, and it is funded properly so that there is no probate. Does it save taxes? The answer is no. So it's a wonderful management tool, but it does not save taxes in and of itself. And the cost of a revocable trust, generally speaking, if it is properly funded, is going to be much less to administer, generally speaking, than a will. So this is the motivation. Someone mentioned earlier, again, minimizing chaos. Someone who does this kind of planning is the person who generally says, I could have a will and it's perfectly fine, but I want to avoid chaos on a higher level. I want to make things smooth. I want to make things predictable. That is why someone would use a revocable trust, even though there are other reasons that sometimes we gravitate towards the use of a trust versus a will. So here's that structure again. You'll notice that the revocable trust again is the centerpiece, but the incapacity planning documents are still very important. And for those of you who may have a little bit more knowledge, you'll understand that the revocable trust also is a tool for incapacity. That's why if we were to redo this graphic, we might call this a revocable living trust here in the circle and not just above that circle. You'll see it's a living trust, and it means during your life, it acts as an incapacity planning tool. All right, now I'm going to round out this discussion of wills versus trusts with other non-probate transfers. So remember, we can have a will, we can have a trust, but here in the middle, we've talked about this already throughout this webinar: joint ownership, beneficiary designations, transfers on death, payable on death. These devices or tools avoid probate. So why not just use these tools for the whole estate plan? Well, the reason in a nutshell is that you don't attain the same amount of flexibility. If I have an asset and I say, I'm driving that asset from point A to point B, well, there it goes. If I die, point A to point B, boom, there it is. But what if this person is predeceased? What if this person has an incapacity at that time? What if this person has a brain injury at that time? What if I have not provided for the flexibility that I want to provide? Well, now that point A to point B analysis becomes more complicated, and I could be creating more problems than I realize. So I would strongly encourage our financial advisor friends and CPA friends who are on this webinar to really understand that, and clients or potential clients to understand that the quick transfer of assets from point A to point B may be contradictory to the purpose of the plan or the purpose of the person developing the plan. So this leads us to a discussion of how assets flow very briefly. And then we're going to do another 60-second exercise. So here we have assets that are flowing. And if you look at the left side here, we have all these kinds of non-probate structured assets. We see them passing to various beneficiaries. But look up top, you see the will or trust, and there was a lot of work, let's say. Let's pretend there was a lot of work, a lot of thought, and a lot of emotional input put into these documents. But look at how the assets are passing. So what I'm trying to illustrate here is that how assets flow, the funding or alignment, however you want to say that about the assets and how they flow in coordination with the estate plan. The coordination or the funding is possibly the most important thing in estate planning. No matter what your documents say, arguably how you own your assets at the time of death is the most important thing in estate planning. So let's take a look at this a little bit different layout, but saying the same thing. I have these assets, but look at the way they're structured. And we see this every week in estate planning. Someone has a wonderful estate plan. They put a lot of time and effort into it, but their assets are being transferred at their death in such a way that all these wonderful plans for incapacity, plans for backup, plans for what if something unexpected happens, are defeated because the assets flow straight to the beneficiary, whether that was a good idea or not. So we don't want to generally rely on these POD, TOD, and other non-probate transfers, even though we want to recognize that they are powerful tools in the proper context. So if we're going to use them, we want to be aware that we're using them and so forth. So I'm getting ready now to shift gears, but before we do that, I would like to just do another 60 seconds, if you don't mind.
Hey, Steve.
Yes, Jeff.
Can we go ahead and pose a question to you before we go that route?
Forgot about the questions, Jeff. My fault.
Wonderful. Yeah, thank you. So we do have one question, and it is, how about 529s? Do you need a joint owner if there is a beneficiary? Is this a probate asset if one owner and a beneficiary? Thanks very much.
Thank you for that question. I can answer the question that it's not a probate asset, but I would have to talk to you offline about that particular question and your particular 529 and how it's set up and you know your particular beneficiary structure. I'd have to talk to you about that offline, but that's a great question. Thank you for that. Okay, now I want any more questions, Jeff?
Nope, that's all for now. Thanks.
Okay, thank you for that question. I'm going to now time you for 60 seconds, and I just want you to ask yourself a few questions, if you don't mind. Do I have a current will, or do I have a current trust? And even if you have a will and you don't have a trust, I'd like you to ask yourself, you know, how are my beneficiary designations structured? If I have a will, one of the most important things that there is in a will-based plan is the beneficiary designation. So if I have a will, is my will updated? Are my powers of attorney updated? My advance directives updated? And not only that, but my beneficiary designated assets, when was the last time I checked that? Now, if you have a revocable trust plan, I'd like you to ask yourself, you know, not only when the last time you updated it, but is my revocable trust funded? Do I have my non-retirement assets in the trust? My cash, my brokerage assets, my stocks and bonds, even savings bonds. Do I have all of those non-retirement assets in the trust properly? Business interests like LLCs, do I have those assigned to the trust? Now, for retirement assets and life insurance, have I properly addressed the beneficiary designations of those assets? And above and beyond that question, I want you to be asking yourself, do I have a spreadsheet for my estate plan that memorializes how everything is that I own, where it is, and that I've done these things so that my fiduciaries know where to find this information. So let's take 60 seconds on that, and I'm going to start that right now. And thank you for your participation today. This whole idea of how assets are owned now, how they flow if we die, this is the real, where the rubber really meets the road in estate planning. No matter how good or how not so good your documents are, that's still the most important thing. All right, we have about 5 seconds left. So just think about that in the quiet of your own room, wherever you may be, and hopefully that is instructive and very helpful for you. Okay, now we're going to switch to incapacity planning. Thank you for your time and attention. We're on schedule. So people are living a long time. And if you haven't experienced this personally, I'm sure your advisor or your counselor would tell you that probably the greatest hazard that we have in this country right now is living a long, long time. So if we're living a long time, do we want to have our incapacity planning in order? Well, here at our firm, we put a great emphasis on this, not just because we're elder law attorneys, but also because we see how long some of our clients are living. So I had a person, a dear person in my conference room a year and a half ago, and I often tell this story now, who was over 105. So this gentleman was in my conference room. His spouse was also very elderly, but they were here to update their planning. Now, that may sound extreme, but it's really not, because those of you on this webinar know that I am speaking the truth, that you yourselves know people that are in their 90s or people that have lived beyond 100. So regardless how long we live, however, the idea is that we need incapacity planning so that if we are incapacitated, someone can step into our shoes. So let's look at this. Next slide. On the financial side, we want to have powers of attorney, financial powers of attorney that are something we understand, something we're comfortable with, something that we've customized to understand the kind of powers that we're giving people and when those powers are effective. By the way, the legislative body, our General Assembly, has passed a bill that updates the power of attorney for Maryland, and that new law goes into effect in October. So those of you who have Maryland statutory powers of attorney, just know that those can be updated after October to include the new version of the statutory form. The old version that you may have is not invalid, so do not worry. But if you want to make sure it's updated, we need to update those statutory powers of attorney. So what happens if we become incapacitated? Well, hopefully we have named an agent. In the financial power of attorney, I want you to imagine the word agent is written right outside that circle. So agent, who is my agent? Who is my successor agent? Why am I so concerned about this? Because if you don't have agents, you're going to be subject to a guardianship of the property. So we want to avoid guardianship so you don't lose your legal rights to your property. On the healthcare side, we want to have healthcare agents. And for some people, this is the most important of all the documents. From an attorney's point of view, the financial powers of attorney are arguably the most important documents because they provide for the greatest financial flexibility. But for many of you, the advanced directive will be one of the most important, if not the most important document. Why are we concerned about having a directive? Well, not only to state our healthcare wishes in advance, but also to avoid guardianship of your person. We don't want to be under the control of the ultimate guardian of a court or someone, these other individuals who are your guardians in person, because you've lost the right to your person and to your property. So here at Elville and Associates, we understand that this is arguably even more important than what happens at death, even though all of that is important, because we want you to keep your right of self-determination. So I want to now go to another couple of slides. These slides we're not going to go into great depth about, but the Maryland statutory power of attorney, the power of attorney that is in the law since 2010, the power of attorney that can be enforceable by law, even to the extent of attorney's fees. That statutory power, even though the updated statutory power now has more powers than the old one, it is still not enough for people who are doing full-fledged estate planning. But for the next several slides, which I'm going to let you review on your own time, those slides show you some of the more enhanced powers that you can include in a general power of attorney. So for those of you who are doing estate planning, those of you who have estate plans, the idea of having more power is generally a good idea depending on your circumstances. So we want to use the Maryland statutory form or forms because there is more than one form. But the simple form is what we usually use in estate planning at our firm to give you the strength of the statutory form, which is its enforceability by law under the penalty of attorney's fees, but also to layer that with a general durable power of attorney that will provide for those more enhanced estate planning powers. So I'm just going to tear through these just a little bit, and you're going to have these for your own review, just so you know that enhanced powers under a power of attorney is something that you can customize, something you have to be comfortable with. And we want to customize your powers of attorney because of their importance. Now, let's just assume that as a given, we've got powers of attorney, we've articulated our agents. Now, let's look at this when question. When does the power become effective? Well, it can be effective immediately. This will make sense to a lot of people. It can be effective only upon your disability, okay? And so these things can be customized, and just know that that's going to be a counseling issue for each particular person. The advanced medical directive, I mentioned, is for some people the most important of all the documents. So this is something I want you to think about. Have I really articulated my specific wishes about my health care, my feelings about end of life, my personal preferences, something that's particular to my healthcare situation? Have I really articulated that? Have I customized my advanced directive? Do you have to customize your advanced directive? And the answer is no. You could use the advanced directive and just go through the basic motions of it. But the point of this slide is to tell you that if you are interested in really customizing your healthcare decision and articulating to your agent what those things are, this is the thing to do. So why am I saying this? Well, most of you may have some familiar relationships where your loved ones know what you want, but other than what you have dictated to them or translated to them orally, they probably don't know anything about what your wishes are. So here is an opportunity for you to do it, and you'll decide how proactive you want to be. The MOLST form is something that's beyond the scope of this discussion. There are life care managers and other medical professionals, nurse practitioners, and doctors who can counsel you about this form. The reason we bring it up to you as attorneys is we want you to know that, as I page back to the advanced directive, we want you to know that there's a relationship, at least from a point of view of education, between these two things. The MOLST is a doctor's order versus the advanced directive, which is not a doctor's order. And part of understanding healthcare decision-making in Maryland is understanding how these documents interact and what you and your loved ones need to know about that. Okay, so I'm going to now take another 60 seconds, and I thank you for being very interactive with me this morning. And before we go to all of these other issues like taxes, let's take another 60 seconds to ask ourselves, when was the last time I thought about my powers of attorney and advanced directives? When is the last time, have I really, maybe is a better question, have I really thought about updating my agents, who those agents should be in these documents as I page back? What order should they serve in? Are there family issues about who should serve first, whether I should have joint agents or not? Who would be better at making financial decisions versus healthcare decisions? Are we a family or a person that's blessed with agents that get along and I can just kind of articulate exactly what I want? Or are there other considerations? Let's take 60 seconds to think about our agents and how we've structured our advanced directives and powers of attorney.
After these 60 seconds, Steve, I'd like to mention a couple things in our chat here.
Thank you. So remember, from an attorney's point of view, nothing is more important than these agents because they give you flexibility at a time of crisis. And the order of your agents, the amount of powers that you give them and when their powers are effective, that's what we're talking about here. 20 more seconds. All right, everyone, I'm going to just time that out for just a second. Jeff has some comments.
Thanks, Steve. As far as going back to your previous inquiry about having everything updated and reviewed and the spreadsheets, we have a gentleman who says that he has a will. His power of his POD and TODs were checked this week, balanced percentages based on value of assets, but 401ks undergoing changes going from 3 to 2 401ks. So sounds like certainly on top of that. So, and then same person actually just responded to your last inquiry here, saying that the advanced medical directive has 2 agents and they have somewhat different views on value of life, quote unquote, as he says.
Yes, so thank you for that. I'm going to give you a real quick feedback on that. So first of all, when you're looking at your will, remember that the POD or TOD will not be controlled by the will. So as you've checked all that, that's great. You're on top of everything, but just remember that's not going to have anything to do with the will necessarily, and maybe you know that already. And then with the agents who don't necessarily see eye to eye on the value of life, this is going to be a question of, at a time of crisis, will my agents get along, and not have some kind of a meltdown that will lead to a guardianship and the kind of the failure of my fiduciary selections and how I see that working. So just keep those things in mind, and there's always counseling and education and maybe restructuring agents and discussions that we can do about that. All right.
Okay, and the other question we have here, is there or do you have a resource for determining capacity?
Yes, thank you. There are many resources for determining this fluid thing called capacity. Some of those resources have to do with American Bar Association standards or publications, but on a practical level, it has to do with assessments by physicians and or licensed clinical social workers. So that is a specific problem that can be addressed in specific ways depending on what the circumstance is. So thank you for that excellent question. All right, well, we're going to move forward now, Jeff, in the interest of time, and we're going to get to now the tax issues. So let's just talk about the current tax environment, at least from the estate planning side, is extremely favorable. Each person has a $12,920,000 exemption from estate tax. These exemptions have become extremely high and unprecedented on the federal level. If you're married, you can leave almost $26 million without any estate tax to your loved ones. The state estate tax exemptions in Maryland are at unprecedented high amounts of $5 million. And these exemptions may rise in the future, the federal and state exemption, but they're indexed for inflation, at least on the federal level. So we can probably expect a higher estate tax exemption next year. But these exemptions are due to reset in 2026, in January 1st of 2026. So we need to be aware over the next couple of years that these exemptions may come down. Some of you may say, well, what will the exemption be? Well, it's going to be cut in half down to about 5.5 million plus an adjusted amount for inflation. So we anticipate that it would be around 6.7, 6.8 million per person. And with the advent of portability, for those of you who are not familiar with that, it means whoever dies first, the survivor, if you're married, can use the exemption amount of the deceased spouse if it has not been used already. It can be used, and now the second spouse to die will have his or her own estate tax exemption, whatever that may be at that time, plus the ported amount of the deceased spouse. So this is a very powerful approach that has been around now for about 10 or 12 years, and there doesn't seem to be any legislative intent to get rid of it. So this portability is a simplification of estate tax planning. And as far as the planning environment, depending on the structure, if you're married, I'm sorry about the folks that are single on the call right now, I'm talking about marriage. The folks that are married, you can exercise control and still have the advantages of some of these income tax and estate tax exemption advantages without giving that up. Remarriage protection, some people are going to use a trust for the survivor, and depending on how that trust is structured, it can qualify for what is called the unlimited marital deduction, which is a deferral of the estate tax until the death of the second spouse. It can provide asset protection for the survivor, and it can also provide for remarriage protection for the children and grandchildren and whatever the goal is in the estate planning. And in the interest of time, we're going to move on now. Let's now switch from the tax arena to the elder care arena. So now some people say, what is the difference between estate planning and elder law? What is the difference? Well, someone earlier, and when they made this nice comment or gave us feedback on this webinar, said they were interested in asset protection. And it was very clear from their comment that they were talking about asset preservation in the long-term care context. And that's what this slide is really illustrating, that when we go from pure estate planning, the conventional estate planning, we're talking about something that now is a transition. Someone may have planned for the general estate planning concerns. How do I leave my assets? How do I avoid taxes? All the things we've talked about this morning. How do I avoid probate? But now something has happened. Something is driving a change in the planning, and that's what this slide is about. Do I want to now focus on asset preservation, flexibility? Should I divest my assets? Someone said I want to provide asset protection and avoid the 5-year look period for Medicaid. How can I do that and still retain some control, or as I say here, unartfully hitting several birds with one stone to have the tax advantages, retain the control, and protect against the claims of beneficiary creditors, have a step up in basis at my death as if I had died with a will? How can I do all that and still preserve assets for long-term care? And then, of course, other issues in elder law: housing, Social Security, long-term care, Medicaid spend down, nursing home placement, assisted living contracts. All of these things have to do with the difference between pure estate planning and how it sometimes melds into the elder law or elder care side as we get older or we have issues with disability. So as we start to wind down now toward the latter part of the presentation, let's talk about asset protection. When Congress made the income tax, at least for the estate planning side of it, the income tax advantages and the estate tax advantages just so unbelievable for 97 to 98% of the people in America, it allows the estate planning community and clients to now look at other issues instead of just constantly being driven by estate tax avoidance and all of the hoops that most people had to jump through to be able to avoid estate tax. Now, is it true that many people are wealthy today in America and they still have to jump through hoops for estate tax planning? The answer is yes. But for the vast majority of people, 98% of people in America without knowing exactly what that statistic is, do not have more than $12.9 million, or they do not have more than $26 million, although many people do. The vast majority do not. So that allows us now to talk about other issues and expand our education. So let's talk about the difference between the different types of asset protection. I'm going to talk about lifetime asset protection versus long-term care asset protection versus asset protection that we can provide others at our deaths. So this is one of the most important slides, not only for married people, but also for single people, to understand the kind of asset protection that some of us already have. So we don't have to go outside ourselves. We don't have to go outside of our normal lives sometimes to have asset protection in some form. So generally speaking, if you're married, you have the opportunity to own property as spouses, husband, wife, husband, whatever the arrangement is, and that tenants by the entirety's ownership is a foundational level of asset protection. If someone were to sue and only sue one of the tenants, they cannot tear that property in half. That's a very fundamental way of looking at it. So the property as a whole is preserved. Now, whether you are married or not, if you have life insurance or annuities, if the beneficiary of the life insurance or annuity is your child, and of course, if you're married, if it's your child or spouse, there is asset protection in the life insurance or annuity proceeds, the death proceeds, all of that is protected from the claims of creditors. Qualified plans such as 401ks, 403bs, 457 plans, these qualified plans are absolutely protected from the claims of creditors. So many of you enjoy that kind of asset protection. IRAs are protected from the claims of creditors. Not 100% in the same way that qualified plans are, but they are largely protected. And if you're a person who has rolled over your qualified plan funds, for example, a government program like a TSP, if you've rolled that into an IRA, the proceeds from that qualified plan into an IRA are still protected. Now, inherited IRAs, the IRAs that we leave others, the IRAs that we may have received from others, not our personal IRAs, but the ones that we have received by inheritance, those do not have asset protection according to a ruling of the Supreme Court many, many years ago. So we still have to worry about that. And if you have substantial IRA assets, which many of you do, and you want those to be protected for beneficiaries in the future, you must leave those IRAs in trust. But that brings up an issue of trust taxation versus the Secure Act, which is something that many of you have heard of, but some of you have not. And the Secure Act says that a healthy beneficiary has to take out their IRA in 10 years. And that means they have to pay tax in 10 years. So we have to be aware of these rules and how they play juxtaposed between trust protection versus income taxation. And all of this is a counseling issue. This last bullet point has to do with those who might seek a domestic asset protection trust. This is lifetime protection, but you cannot do that in Maryland. You can have something similar to this if you're married, called a lifetime marital trust. But for those of you who are looking to do domestic asset protection, for example, in Alaska or Nevada or Delaware next door to us, or South Dakota, Wyoming, these kinds of trusts are available in the US in about 16 to 17 jurisdictions. Now, in the long-term care context, as we start to wind down to our last 10 minutes or so, we're back to elder care. So we're back to asset preservation. As the participant said earlier, I'm protecting assets from the, hopefully to get beyond the 5-year period for Medicaid. So the use of the Medicaid Asset Protection Trust, which is a hybrid irrevocable trust that has been developed over the last 15 or 20 years by the elder law community in the US, not just in Maryland. These asset protection trusts are a powerful tool. I would argue they may be the most powerful tool in estate planning to allow someone to divest assets, whether it's for Medicaid or not, but to divest assets mainly for Medicaid purposes, to still retain some control over the assets and still retain the income tax benefits and the asset protection benefits for the beneficiaries that the assets are being gifted to or against the creditors of the potential creditors, I should say, of those beneficiaries. In other words, a multifaceted tool for protection. The same thing is for the Veterans Asset Protection Trust, which is another hybrid version of an irrevocable trust for those of you who, or those relatives of yours who may need or be qualified for VA trust, and also the VA pension is what I'm really trying to say. The Veterans Administration has many pensions, and these pensions are tax-free, and this one is referring to what I would call the VA aid and attendance benefit. So this tax-free benefit is something that sometimes we have to plan for because the VA rules have changed since 2018. Some of these rules are very favorable, some of them make it more difficult, but we work around those rules, and now the Medicaid rules and the VA rules have become more aligned in some ways. So it makes it easier in the long run to hopefully save assets for someone who would be qualified for a VA pension. The federal law and now the state law allows for spousal planning in elder law. So the use of wills the use of trusts, I should say, under wills is a very, very strong strategy for couples where one of the spouses has a diminished capacity or some kind of progressive illness. So that kind of elder care strategy has to do with preserving assets. So the Medicaid trust, the Veterans Trust, the use of trusts under wills for spouses in a spousal situation. The augmented estate is a very complex way of saying that in 2020, Maryland changed the laws, and there was a compromise in the law that said where we have a couple that wants to protect assets in this particular strategy of using a will to provide a trust for an ill spouse. So what I'm talking about is a well spouse dies first, leaves a trust for a disabled spouse. The Maryland law now has parameters that are very clear that if we follow those parameters, Maryland will not seek to recover. This is a really powerful strategy, will not seek to recover against that couple. And so that's a very, very powerful tool. The look period, someone mentioned that earlier, that is a 5-year period. So if we divest assets, we have to survive through a 5-year period without applying for Medicaid long-term care benefits. If we get past that period, then we will have preserved, under the current law, we will have preserved the assets that were divested. The rule of halves, this is something that's very critical to know, and normally you would find this out through an elder law consultation, but the rule of halves basically says that if I have a certain amount of assets and I'm a single person and I need long-term care skilled nursing, now with the proper approach and the proper strategy, I should be able to save roughly 50% of those assets and still qualify for Medicaid long-term care benefits. Life estate deeds are a very simple way, but not with any flexibility. A simple way, though, to be able to put a piece of real estate, like a residence, into a 5-year look status. And it can accomplish the same goal as a Medicaid trust, but just not with so much flexibility. So these are not used as much anymore, but these are very popular tools that are kind of one-dimensional. In a certain circumstance, that could be the right approach for someone. Now, as we switch to the final piece of our asset protection discussion, we've talked about lifetime asset protection. We've talked about long-term care asset protection and how to think about that. Now, this is asset protection at death, and probably this is the easiest thing to do other than the actual part of having to die to accomplish it, not trying to be funny. The idea of dying and we can leave at our deaths a further spendthrift protected trust for loved ones, whether this is a spouse, whether this is a child or niece or nephew, or a special needs loved one with disabilities under a special needs trust. And we can structure these trusts to be more flexible, which we strongly recommend in most cases, or more straightforward, whatever the need is and whatever the desired goal is. But we can use trust protectors and we can use other special fiduciaries to provide flexibility in these trusts. And under Maryland law and many state laws, these trusts can last in perpetuity. So these are tools that also can be used in the Medicaid planning context. So in other words, if we were using a Medicaid trust, we could drive those assets at the death of the beneficiary, at the death of the grantor, down to the beneficiaries in perpetuity. So these tools are available. It's important just to understand what asset protection is, what context of asset protection we're talking about, and what your goal is as far as asset protection. So once we understand those things, we can kind of get to where we need to be, just like in any other venture. The Secure Act, we talked about that very briefly. It was signed into law in 2020, actually at the end of 2019, but became law in 2020. This is going to affect most estate plans, not all estate plans, but most. It effectively ended the stretch IRA, the ability for a healthy beneficiary to stretch this taxation out if they don't need the money until their mid-80s, basically. So Uncle Sam is going to be taxing trillions of dollars of income taxed IRAs very quickly because beneficiaries are now mandated to have to basically take those IRA funds out over a 10-year period. And so Congress or the Treasury continues to update these regulations, and those of you who follow Elville and Associates Communications will keep you updated. Now, there are some exceptions to the Secure Act, and I'm just going to quickly name those if you're not familiar with them. So spouses are exempt. So surviving spouses are exempt from the Secure Act. People who are less than 10 years younger, people who are less than 10 years younger than the plan participant, that's kind of a strange one. Minors are exempt until they are 21. Now, minors are minors until age 18 as far as the age of emancipation, but for the purposes of the Secure Act, someone is not an adult until age 21. So minors are exempt under the Secure Act until age 21. Chronically ill individuals are exempt, as well as their special needs trusts, and persons with disabilities are exempt, as well as their special needs trusts or supplemental needs trusts. So all plans need to be reviewed. There are ways of dealing with this onerous, quick taxation for those of you who have really focused your retirement plan savings and build up a lot of retirement plan assets. There are a few strategies that we are happy to discuss with you, but just know this is something that we do have to deal with, and there's no indication that it will be going away anytime soon. At Elville and Associates, we have a client care program so that we can educate you, but also continue to educate you to keep the plans maintained, to keep your loved ones and fiduciaries educated. So this is something that we're very proud of, and we're having an upcoming event in September for our social event for our CCP, our client care program. So we're very excited about that. But we're one of the only firms in Maryland with a client care program from the Client Care Academy in Boston, and we're very proud of that. So I just included a few slides here so that you would know that at a firm like Elville and Associates, we are interested in being partners with you. We don't believe in just pure transactions unless they're absolutely needed. We want a lifetime relationship with you, and the only way that we can really do that, and the only way that's good for you, is if we offer a path forward. So education is great. We believe in it. We want you to be educated, and we thank you for your participation, but we also want to provide a path forward. So that's what this is all about, and I'm just going to leave these slides here for your review as we start to wrap up on time. And we just really thank you for your participation and your feedback, your comments, and your proactivity. And I'm just going to say, we should meet to review. We want to review. We don't charge for estate planning consultations, generally speaking. We do charge for elder law type conversations because those types of conversations tend to be conversations that have to do with current legal advice under some kind of crisis situation. But if it's a planning related consultation, we do not charge for those consultations. We want you to relax and understand there's nothing to fear, because in those types of consultations, there is an attorney-client relationship. There is confidentiality. So there's nothing to fear by coming and talking about what's on your mind. We want to see your current documents if you have current documents. If you don't have current documents, We are just going to be very excited to see you and help you determine whether we're the right firm for you. We want to help you build a collaborative team, which we didn't talk about too much today. I kind of skipped over that a little bit in the interest of some of the surveys and comments we were getting from you. We want to have a collaborative team or help you form one. And if you already have a team, a financial advisor or a CPA you're very happy with, we want to collaborate with them. A life insurance professional, we want to collaborate with them and make sure that we are talking to them and they are talking among themselves. This is in your best interest. We should not have a collaborative team that is really not talking, because that's not very collaborative. We want to answer questions that you may have. So please bring your list of questions. That's important. But we want to give you time to think, really is the most important thing. We want to help you know and formulate your goals. We want to educate you so that you know, well, these techniques are available to us, and we can either take those under advisement and not use them, or we can engage in those kinds of techniques. But we give you the space and the time to think in our conference rooms here at our Columbia office or wherever else we may meet. And I wanted to just end by saying, whether you are a couple, a married couple, a partnership where you have a domestic partnership or partners that live together, whether it is a single person who is a male or female or identifies otherwise, we are here. We have 8 attorneys here. We have male and female attorneys. We want to make this an experience where you feel cared for, where there's compassion and where there's counseling. And we can customize an estate plan to your goals. So with that, I thank you for everything and your time especially. And Jeff, I'm going to turn it back to you.
All right, Steve, thank you so much for the great presentation. Lots of really helpful information, and really like the new approach to working to include everybody and get their feedback. I thought that was really well done. So we do have a couple of questions. So now, as always, would be your time to get those final questions in for Steve. You've got Steve Elville captive here for another 10 minutes or so. So don't hesitate in getting those last questions in to speak to Steve here. First question we do have for you, Steve, is what should one consider with revocable versus non-revocable trust planning?
That's a wonderful question. Thank you for that. I'll try to be brief. Your revocable trust planning is, remember, a substitute for a will. So this is our conventional routine approach to basically say, I want a great incapacity planning tool. I want to keep things as easy as possible for my loved ones. I want a smooth administration with the lowest possible cost. Those are generally why you're going to have that revocable trust. An irrevocable trust approach, a very high level, or I guess very broad level way of describing it would be, I have a special purpose. Other than avoiding probate and these conventional reasons, I have a particular special thing I'm trying to accomplish. I'm going to develop an irrevocable trust for charitable giving. Those types of trusts are irrevocable. I'm going to develop a Medicaid trust. That's an irrevocable trust for asset protection. I'm going to develop a life insurance trust because I have a large life insurance policy and I don't want that in my estate. I'm developing a spousal lifetime access trust. That's an advanced tool, but that's an irrevocable trust to do estate tax planning and do it in a large way. So it depends on what your specific goal is, and that's how I would think about it. An irrevocable trust is a trust, to my mind, that has a specific reason, a specific goal in mind, not just the conventional routine revocable trust.
Okay, next question, thank you. Would you happen to know the current exemption for taxes in New York?
Oh, that's a great question. I don't know the answer to that, and I apologize. I want to say that New York does not follow the federal exemption, that they have their own state tax exemption, but that's just a recollection of mine. We could easily find out for you if you would email Jeff. We'll get back to you.
I believe, and again, as a non-attorney, I believe if you were to Google that, which I did when I saw the question, that answer would pop up very quickly for you. But we can also look into it as well for you if you'd like. Also, thank you from our friend Emily, who's with the Baltimore County Department of Aging Caregiver Program as a dementia specialist. So thank you, Emily, for being here.
Thank you.
Please talk about considerations with international property and if you establish banking out of the U.S. in regard to your estate. Thoughts about that, Steve?
Yeah, that's a great question. So that's a very, very specific and at the same time a very broad subject. So that would have to be fact specific for me to comment on it. But generally speaking, every country is going to have their own laws with regard to succession and disposition of assets. Some countries are civil law countries. Some countries are English common law countries. Some countries are members of the International Wills Act. So depending on where the property is, what country it is, depending on what your citizenship, depending on the citizenship of your spouse, if you're married or not, these are the considerations. And depending on whether you leave assets in further trust will depend on the type of trustee selection and so forth that has to be thought about. So thank you for that question. It's very broad, and I apologize I can't specifically address that. It is possible, if I understand your question, it is possible to use foreign banks in some instances to transfer funds. In many instances, even if there's beneficiaries overseas, we'll use U.S. banks because the trust, of course, is a U.S. trust. So very broad, but we'd be happy to really drill down into that for you.
Sure. And it looks like last question for now would be, can spouses change their trust without the other's consent?
Very good question. So it's going to depend on what kind of trust you are talking about. And I'm assuming you're talking about a revocable living trust, a basic will substitute. So some trusts are going to be joint trusts where spouses have been together for a long time. They have a lot of joint assets, and therefore they mutually agree to have a joint trust, a trust where both of them are using the same trust, but it feels pretty much like joint ownership of assets, and psychologically it's comfortable. Now, in many of those trusts, it's not going to be possible to change the trust as far as the total approach in the trust without the cooperation of both people. Now, with that said, it is possible to use a joint trust and have separate assets owned by that trust. So it's going to depend on how that joint trust is drafted, because those can be tricky, and those have been tricky, not only in how they can be drafted, but in their treatment with the IRS over the last 20 years. Getting more clarity in the last several years on that. But if you have a separate revocable trust, you're the grantor of your own separate trust, there's no question that you most likely have the ability in that revocable trust to change your own trust, because you're the grantor of that trust, and no one can really stop you from changing your own trust. So in the joint revocable trust, it's going to depend on the structure. In the separate revocable trust, I don't think there's any question that you would have the ability to change your trust.
Okay, and we have one more. A few words on timeshares. Love them, hate them, let them die with a spouse, or an asset to children. Any thoughts, Steve?
Well, the timeshare question is one of those endless subjects. So I don't really have a good answer for you, except to say many clients have timeshares. Many clients love timeshares, and many clients are very attached to their timeshare. So I think they're a great thing to have. They bring happiness to many people. Some people have timeshares that are so exclusive, it's really a focus of the plan. Every once in a while that happens. But generally speaking, timeshares are difficult to dispose of if we don't want them, and sometimes we're concerned that our beneficiaries don't want them. But I think that's a case-by-case thing, and I think it's going to be dependent on the management company, the quality of the timeshare, the location of the timeshare, and its relative value to you and to the beneficiaries. So it's a broad subject, and happy to discuss it in specifics.
Okay, thank you. All right, so as I always try to do, I send a follow-up message with a lot of information from today, the video link from today, which is always very popular. We have a YouTube channel here at Elville & Associates, which houses all of our webinars from the past many years. I bet you all didn't know that, even though I've mentioned it many times. But I will send the link out to you and hope that will be a great resource to you for our YouTube channel as well as today's video. Also, as far as our webinar series goes, we have Marilyn Abel and Kelly Nelson, the outreach coordinator for Marilyn Abel, coming back on Tuesday, the 12th of September to talk all about Marilyn Abel accounts and all the changes and benefits of Marilyn Abel. Looking forward to her visit. She's always so wonderful. We have our advisors forum for our financial advisors and other professionals coming up on September 13th as well. And then we jump to September 27th, where Steve will be back to talk about legacy and charitable giving and philanthropy. Looking forward to that. And to round out September, we have Understanding Estate and Trust Administration on September 29th. So a pretty busy month in the webinar series. So I always want to thank you for your interest in Elville & Associates and your continued support of the Elville webinar series. And we look forward to seeing you again soon and hope you have a great Labor Day weekend. Thanks again.